This is an appeal in the matter of Kireeva and Zolotova.
Yes.
May it please the court, I appear for the appellant, Mr. Kireeva, together with Mr. Nugee, and my learned friend, Mr. Bradley, whose counsel appears for the respondent, Miss Zolotova. My lords, before I begin, can I just check as regards the supplementary bundle? There was two pieces of correspondence added by the respondent, Miss Zolotova, and then in response we have one-page letter and two decisions of Lord Justice Arnold at tab 30. We sent them last night, and I just want to...
We have.
You have them, and I'm grateful, my lord, if they could be had.
There have been three
Yes.
decisions in all of Lord Justice Arnold.
Yes.
I've got them all in the same place.
I'm grateful.
It's not necessary to obtain permission to put interlocutory court orders in London. But anyway, we have them. Thank you.
I'm grateful, my lord. This is an appeal from the order of Sir Anthony Mann, brought with the permission of Lord Justice Arnold. The court will have seen from the skeletons that Miss Kireeva is the trustee in the bankruptcy of the estate of Mr. Bedmazov. Mr. Bedmazov is accused of a very substantial fraud in respect of a bank of which he was once president. And the trustee seeks to establish the ownership of the share of an English company, Basel Properties, that owns a very valuable Italian villa in Sorrento. Now, Mr. Bedmazov transferred the Basel share to the respondent, Miss Zolotova, on the 1st of April 2016, and that was shortly after the bank had been placed into bankruptcy. And the trustee alleges that Miss Zolotova holds the Basel share on trust for Mr. Bedmazov. Trustee says the transfer is of no legal effect, or that it falls to be set aside as a transaction at an undervalue pursuant to section 423 of the Insolvency Act. And my lords, Mr. Bedmazov is the subject of a worldwide freezing order granted by this court. Given the dissipation of assets from Mr. Bedmazov's estate, Miss Kireeva, as the bankruptcy trustee, has needed litigation funding to fund her claim against Miss Zolotova. Miss Kireeva gave security for the costs of trial of Miss Zolotova in the sum of £655,700. But in the summer of last year, the trustee had funding difficulties and she applied to adjourn the trial that had been set down for July of 2024. Now, in a judgment of June 2024, which is core bundle tab 11, and I'll come to it later, the judge, Sir Anthony Mann, ordered the claimant, through her solicitor, then Mr. Elliott, to file a certificate by the 31st of August 2024 to confirm various matters in respect of the funding arrangements for the trial. And as part of that order, he relisted the trial for early November 2024. Now, that June order is at core bundle tab 10. And if I just invite the court at this stage to take it up.
Yes.
So core 10, page 97. This is the order that adjourned the trial. And if the court turns to page 98, for relevant purposes, paragraph 2, Sir Anthony Mann ordered the claimant, i.e. the trustee, by the 31st of August to pay Miss Zolotova's costs of the application and the wasted costs of the original trial. And then importantly, for this appeal, paragraph 4, the judge ordered the claimant, through her solicitor, to file a certificate. And the court will see there are two limbs. One, a certificate stating that funding arrangements are in place, and two, to provide details of the banking route by which such funding will be provided. On the 30th of August, so the day before the court's deadline, Mr. Elliott filed the certificate. Now, that certificate, just for the court's note, is in the supplementary bundle, tab 4. If we go to page 26, this is the email that Mr. Elliott sends to the court attaching a letter and the certificate itself is at page 28. The court will see at page 28 that DCQ Legal, Mr. Elliott, we certify and confirm on behalf of the claimant, 1, funding arrangements are in place to allow the trial in these proceedings to take place, and 2, the route for the funding will be provided by Cesar Consulting, the claimant's funder, using the bank account of its owner, Mr. Libashitz, at Raiffeisen Bank, Moscow, Russia, to transfer funds directly to this firm. Raiffeisen is an Austrian bank, but it has a Moscow branch. Also on the 30th of August, the claimant...
Do we know what formally means?
My lords, formally at...
Raiffeisen Bank ZAO, which
formally as in previously, I think, rather than... I don't know, my lord, but that's how I have interpreted formally. I don't know the answer, my lord, to that.
Okay.
Is ZAO an Austrian abbreviation for limited company?
Probably Russian.
It's a Russian, so I suspect, my lord, it's a Russian branch of the Raiffeisen Bank, which is or not, yes. And also on the same day, the 1st of August, the claimant paid the wasted costs for paragraph 2 of the trial. Now, my lords, this appeal concerns the judgment that was given in October of 2024. So if we go back to the core bundle, and it's tabbed...
The order is dated 28th of June.
Yes.
And that was the actual trial date.
No, the trial, I believe, was about to commence in early July, so very shortly before. And what happened is, effectively on the eve of the trial, the claimant applied through her solicitor, and Mr. Justice Anthony Mann decided to adjourn. The judgment's at tab 9. We will look at that adjournment judgment, and the order then is made.
My lord, I'm loath to interrupt, but the 28th of June was day 1 of the trial listed for reading.
Reading day.
Oh, I'm grateful to my learned friend.
Yes, and the application was made on the previous Thursday, the 24th?
On the 24th, on the Monday, and Friday was the 28th.
I'm grateful. Now, my lords, this appeal concerns the judgment that is given at core bundle tab 9.
Yes.
And the judge held the certificate that we've just looked at was invalid, as in effect, such that the valuable claim against Ms. Zolotova stood struck out as a result of the June order. And that was despite the fact that Ms. Zolotova was protected for her cost of trial in terms of the security that had already been placed in the court. Now, my lords, I say, yes. My lords, I say this appeal should be allowed. And the claim should go to trial. And I have 3 grounds of appeal. They're set out at core bundle tab 2.
Yes.
Ground 1 concerns the proper construction of the order requiring the certificate. Effectively, what did that June order mean? And I say that in the context of and against the backdrop of the June judgment that we will look at, the judge was wrong to hold that limb 2 of the certificate was inaccurate in any material sense. And the short submission is that limb 2 did not need to provide details of any, quote, intermediate step to certify the banking route. The answers, the information given, complied with the terms of the order. The second ground, my lords, is that the judge was wrong to find the certificate was provided in bad faith. The judge held expressly that both the claimant, the trustee, and the solicitor, Mr. Elliott, who actually provided the certificate, acted honestly. But he nonetheless found the certificate was given in bad faith because of findings he made against the funder, Mr. Libashitz, and the funder's lawyer, a gentleman called Mr. Nugee.
Did he find that Mr. Elliott acted honestly? I thought it was more nuanced than that. He expressed considerable scepticism about Mr. Elliott and declined to find that he acted in bad faith, which is not quite the same as saying I'm making a positive finding he acted honestly.
Well, I would accept that, and we will look at the judgment because it is correct to say that in a paragraph of the judgment, the Sir Anthony Mann did express scepticism about Mr. Elliott. When we look at the evidence, I will say that is an unfair criticism, but for my purposes, the important point is that there is no finding of dishonesty against the solicitor. But I accept there are shades, if you like, on a spectrum between good faith and bad faith, but we are not at the bad faith spectrum for Mr. Elliott. And I do say that because the judge declined to find bad faith or dishonesty against the claimant and the solicitor, there wasn't a basis, a proper basis, I say, to impugn the validity of the certificate. And on that basis, I say the certificate was not invalid and ground 2 succeeds. And the third ground concerns abuse of process, and this is a short ground because in my submission there's no separate freestanding abuse of process point. If there was a valid and effective certificate, which is the premise of ground 3, then I say there could be no abuse of process to provide that valid and effective certificate or to rely on it. And I certainly say it wasn't proportionate to strike out the claim as an abuse of process. So, my Lords, what I'm going to do is I'm going to structure my submissions by reference to those grounds and go through the judgment by reference to those grounds. And that's probably the most convenient way to do so. And I will also address, so far as I need to at this stage, the respondent's notice. Effectively, as the court knows, my learned friend says the judge should also have found that limb 1 of the certificate was false, and that was contrary to what the judge found. Limb 1, we will look at it, concerns the funding arrangements, and I will explain that the matters on which my learned friends rely actually show why my construction of the order is the correct one, but we'll come to that in due course. So, my Lords, can I begin then with ground 1, effectively what does the order mean? And if we go, please, first to my skeleton at Core Bundle tab 5, page 34, this is simply just to set out the relevant principles. I don't believe there's anything in dispute between the parties on how you construe the order. Certainly Ms. Zolotova doesn't take issue with the principles in her skeleton. Pan Petroleum, paragraphs 41 to 42 in the Authorities Bundle, tab 17, gives a summary. In effect, as the court would expect, you construe the order objectively and in context. Actually, if we look at it, Lord Justice Nugee, I see, has raised the Authorities Bundle. So it's page 328 in Pan Petroleum. And it's quoting the Supreme Court from Abiyazov. And the court will see at the foot of the page, the sole question for the court is what the order means. And if we go over the page, importantly, 329, in considering the meaning of an order granting an injunction, the terms in which it was made are to be restrictively construed. And I say that also applies when we come to unless orders, and there's authority to that approach, to that effect.
But it's a slightly different point, isn't it? It's not that the order carries the contempt sanction. You say unless orders should be strictly construed anyway.
Yes, because of the draconian consequence that it would be struck out. And the Court of Appeal in Real Credit makes that point. And paragraph 3, the words of the order to begin their natural and ordinary meaning to be construed in their context, including their historical context, in regard to the object of the order. And then, if we look at paragraph 42, what the court said, it reiterates the objective construction point and the reasons given by the court for making the order. And they quote the speech of Lord Sumption in Sans Souci. And the court will see in the middle of the paragraph the reasons for making the order, which are given by the court in its judgment, are an overt and authoritative statement of the circumstances, which it regards as relevant, and they are therefore always admissible to construe the order. And that's why we need to look at the June judgment, importantly, to understand the words of the order.
It's very helpful to have that set out by Lord Justice Flo, but I have to say that none of that comes as a surprise.
No, my Lord, it doesn't. Save that, of course, it's important. My submission would be, in effect, that what the judge did here was to read words into the order which were not there, and effectively have an expansive interpretation that wasn't justified. Now, my Lord, so to construe the order correctly, we do need to place the certificate in its relevant context. If I can then pick up the judgment itself, which conveniently summarises the position, and that's the core bundle tab 9. And we can pick it up, my lords, at paragraph 5, which is page 81, where Sir Anthony Mann refers first at paragraph 5 to the application for the adjournment, and he refers to the evidence that was before him at the time from Mr. Elliot, and he says, I will not set out again here the issues. We need to look, however, at that previous June judgment. And he then says, I draw attention to the fact that reference was made to failed attempts to get payments out through an Italian bank and a Hungarian bank, a failed attempt to get funds out through some unspecified arrangement in Dubai, which now looks as though it might have been an agency agreement. Just to note there, there's another route that was in the June judgment that Sir Anthony Mann doesn't refer to here. That was the personal bank account of the funder. I'll make that good in a moment. Then at paragraph 6, the judge says he granted the adjournment on strict terms because of the apparent problems surrounding funding and its routing out of Russia. And then he says he orders the certificate. And then he quotes paragraph 11 of his June judgment. So if you just look at that, please. First, so this is the fourth line of paragraph 11. He says that the timing needs to be strict. First available date after the 7th of October. Second, this is about halfway down. It says, second, the claimant must pay the cost of this application and the costs thrown away. As a condition, by pay I mean actually pay. And he says this, the way of achieving that is by making an order that those costs shall be paid by the 31st of August, failing which an action will stand dismissed. I appreciate this means that the or a funding route must be available by then, but I require it nonetheless. So the payment of the costs is linked to the availability of a funding route by the 31st of August. And then third, the claimant is not to have an extended time to get the fund routing in place. He goes on, there must be a date by which it's apparent whether a funding route is in place or not, and here must be a reasonable amount of clarity and transparency about the ability of the claimant to take the case to trial. I shall therefore make an order that the claimant must, by the 31st of August, certify through her solicitors, funding arrangements are in place to allow the October trial to take place. And he then says, I will not allow this trial to be adjourned and let's see what happens by the date of trial basis. I appreciate this is an unusual order. Circumstances of the case justify it. I make it clear that it is the banking route that has to be provided and a general certificate to the effect that funds are available, not full details of the source of funding. So, my lord, that is the basis on which the June order, which we have looked at, was granted. Can we now look at the June judgment itself, which is core bundle tab 11, page 99. So this is the judgment given on the 28th of June. And Sir Anthony Mann, first of all, refers to the background, and we can really pick it up again, paragraph 6.
This is presumably an unreserved judgment.
Yes, as I understand it was on paper. Yes, I'll go for confirmation. Yes, my lord.
What do you mean, the whole application was dealt with on paper?
I believe it was, yes.
Thank you.
And if we go please to page 103, paragraph 6, this is where Sir Anthony Mann refers to the filing of the application to adjourn the trial, and he refers to the fact that Cesar, that's Mr. Libeschitz's vehicle company, has not managed to establish a route by which funds can be provided to fund the trial. This is the trial that's about to take place. And he says the application was supported by a witness statement of Mr. Elliot. That is Mr. Elliott's 24th witness statement. The court's notice at the supplemental bundle tab 2, page 7, and we may come to it if necessary in due course. And then what the judge does is effectively he summarises what's in the evidence from Mr. Elliott from 6A to 6K over the page. And I just need to pick up a few points. First, at 6A, he talks about the fact that money is owed to Mr. Elliott's firm at the time Caesar took over the funding arrangements. That's a reference to funding arrangements. He talks about the the historic costs as well as the costs going forward. If we turn over the page, please. 104, paragraph B, there's a reference to security. The total security was in fact 655,000, but Caesar provided 500,000 of that. There'd been a previous order for security of 155. And then C is important. Further fees have accrued due. Money owed to counsel. Apparently the claimant was relying on the goodwill of counsel, while Caesar tried so far unsuccessfully to find a route for payment of funds from Russia to England. Then at D, Mr. Elliott, this is Mr. Elliott, a summary of his evidence, talks about what the funder has been doing. And you see at D that Caesar attempted to open non-Russian bank accounts. And applications were made as an Italian and a Hungarian bank. And the judge says at the date of the first witness statement, the application for the account at, quote, the Spanish bank has not been approved. That is a typo, my lords. That must be the Italian bank. As for the Hungarian bank, an account had been opened, but payments had not been authorised. And then the judge records that Mr. Elliott, in his reply statement, discloses that the Hungarian bank has announced it will not process any further currency transfers. Then he says this, so that particular route no longer seems to be open. That's the words that the judge uses summarising Mr. Elliott's evidence. At E, he refers to another route. These are payments, sporadic payments, from the personal account of Mr. Liebeschietz, but from the reply witness statement, that too has dried up because his bank will not be making any further payments. And the bank is Raiffeisen Bank. You can see that in the evidence. And that's what's said at E. And then at F, he refers to the Dubai route. And you will see at F, the judge quotes Mr. Elliott, this payment route has not been made available. And then at G, importantly, the judge says that Mr. Elliott's firm was satisfied that Mr. Liebeschietz had sufficient funds in order to fund this litigation. Otherwise, they would not have agreed to continue working on the case when the funding arrangements changed. The precise details of that have not been disclosed. So that is a summary of the evidence, the judge's summary of the evidence. And what he then does at paragraph 7 is he draws together the facts and the background. And this is the important point, really. 7 Roman 4 is where I think we should start. He says the difficulties of the claimant's own making. She's entered into, quote, funding arrangements with a funder who apparently cannot provide funds in this jurisdiction. So I've gone over the page now to 106. Then the judge says at Roman 5, problem is not one which has emerged only recently. Roman 6, he makes the point that fees have been paid historically. Roman 7, he does make the point that the fact the defendant, Miss Zolotova, was not alerted to the problem until very recently is, quote, I suppose understandable, since it's obviously a bad move to alert an opponent to this sort of difficulty when it is hoped it would be overcome. And then Roman 10 is the important point. It has become less rather than more clear what funding route will or can be provided to two anticipated routes, brackets, the Hungarian bank and Mr. Libashit's personal account have now been closed off. So that is a banking route, Mr. Libashit's personal account. That's been closed off at this stage. The judge goes on. It's not clear what will happen about the Dubai route. So the
When he says Mr. Libashit's personal account has now been closed off,
yes.
it doesn't mean the account's been closed. It means you cannot now transfer money from Mr. Libashit's personal account direct to the solicitors in England, because that's
Correct.
what he has previously recited from the evidence. 6E,
Yes.
it seems that too has dried up, i.e. the ability to get money out of the Russian personal account of Mr. Libashit's, because his bank will not be making any further payments.
Yes, so the route, the funding route, a banking route, the account, Mr. Libashit's account, just like the Hungarian bank account was a funding route, is no longer available. Of course, the account isn't closed, but it's no longer available as a banking route.
The route there means getting from Mr. Libashit's Russian account to the English list.
Correct. Yes, exactly. Yes, I accept that. In the same way that the Hungarian bank account was also a banking route, and also it's called Spanish, but the judge means Italian. The Italian account, at this stage, as you can see from Roman 10, is the only possibility, but it's been overwhelmed. Some lords, that is the context in which the judge then says at paragraph 11, we go on to page 109, he makes his order, which we've just looked at. And my submission is that when the judge is talking about the banking route, he has in mind, objectively, a banking route other than the Hungarian bank account, Mr. Libashit's bank account, the Italian bank account, or Dubai. Those are potential banking routes, but at this stage, they are not available to the claimant. When you ask, well, what does the judge mean objectively by the banking route? A banking route could be the Hungarian bank account, or the Italian bank account, or Mr. Libashit's personal account. That's what it means for the purposes of this order. And that's the context in which the judge says you need to get a fund routing in place. The court grants the adjournment. So we then turn back, please, to the judgment. Core bundle tab 9. We were looking at paragraph 6. We look at paragraph 7, page 82. Yes?
Can I just stop you first? I mean, you said that what the judge means is an account, but the Hungarian bank account or the Italian bank account or Mr. Libashit's Russian account. But it clearly doesn't mean that a route is available simply because an account is available. Mr. Libashit's Russian account was available on the evidence at the time he made this order. That is clearly not sufficient to satisfy the requirement for the route to be specified. What he means, it seems to me, and tell me if this is in your submission wrong, is a means of getting money from A to B. And he's already said, on the evidence at the moment, some money has come from Mr. Libashit's Russian bank account to England because people have been paid. But that has now dried up, so that's not a route that's currently available. What he means by that is, at the moment you can't get money out from Mr. Libashit's bank account to England. So saying a route is an account is not accurate. What he means is an account from which you can make payments which will arrive in England. It's a separate question whether you have to specify quite how you get to England, but it clearly means that there's only a route available, not just if you have money sitting in Moscow, but if you can transfer the money from Moscow to London.
My lord, yes, I would accept that. Yes, I accept that. But when we look at what details of the banking route mean, in my submission, we'll look at it in a moment. At the time, when we look at the evidence, a transfer from Mr. Lubishit's personal account to England, in my submission, was possible. And the reason I say that is that the money that comes to Steptoe is paid directly after the certificate is filed. I'll come to the evidence on that. And Lord, as to answer Lord Justice Nugee's point, yes, I accept that. It's not merely the account, but what the judge does have in mind is, at this stage, transfers from various banking routes have not become available, or no longer available. So you, claimant, need to find something else. What changes, as we'll come to by the 30th of August, is that Mr. Lubishit's personal account has become available. And there's an argument as to what happens after that. We'll look at that in a moment. So, my lords, if we turn back to the judgment, please, paragraph 8, this is page, so C tab 9, page 83. Paragraph 7 recites the order, which we've looked at, and paragraph 8 then refers to the costs that were paid on the 30th of August. And we saw from the judgment the whole purpose of the certificate, within the judge's mind, was there needs to be a route in place by the 31st of August to pay the wasted costs, and they're paid on the 30th of August. And then paragraph 9 of the judgment, Sir Anthony Mann refers to the Raiffeisen Bank, and he says that previously there was a limit, and at least for a time no transfers were permitted. And paragraph 10, he refers to the fact that on the 2nd of September, the respondent solicitor writes to say that Raiffeisen Bank had announced on the 15th of August that, say, for certain transfers, it would cease cross-border transfers in foreign currencies, so not all transfers, foreign currencies, from the 2nd of September, and no transfers other than the limited ones referred to would be effected after 4 p.m. Moscow time. And in paragraph 11, the judge says this: in the last week of August, and therefore not long before the 30th of August deadline, DCQ, that's the claimant solicitors, received funds sufficient to pay their outstanding fees. And the funds came from the Raiffeisen Bank account. And on the 30th of August, Steptoe, solicitors who came on the record later, also received a sum of just over £403,000. And just pausing there, the judge refers to deadline as the 30th of August. That's the Raiffeisen Bank deadline. But there's another deadline. That's the deadline in the order, which is the 31st of August. It is a coincidence that the deadline for the judge's order is the 31st of August, and the Raiffeisen Bank deadline is the 30th of August. But it's an important point, because when we look at the evidence, the judge places much weight on the fact that Mr. Lubishitz and Mr. Nurtinov made payment driven by the 30th of August deadline. And he says, well, therefore they must have known about this. Whereas in fact, as we'll see in the evidence, the reason why payment is made on the 30th of August is because Mr. Elliot had asked them to make payment by the 31st of August. I'll show the court in the evidence on that, but it's an important point which we'll come to. Then we come to paragraph...
Sorry,
yes.
I don't see where the judge says deadline.
Oh, sorry, my lord. Paragraph 11, the first line.
I see, 30th of August.
Yes, so in the
much.
judge's mind, that's the RB deadline, whereas in fact, the important point is, I say, is the deadline in the order, the 31st of August. Then we come paragraph 12, the present application. So it's made on the 10th of October after various probing correspondence. And what happened is there was one day for the claimant, Ms. Kireeva, to put in her evidence, the 11th of October, that was a Friday, and we had the hearing on the 12th, the Tuesday. For what it's worth, there was no permission for reply evidence, but Ms. Zolotova put in reply evidence a few hours before the skeleton on the Monday. Now, there are 2 points to note at this stage. The first is that the complaint by the respondent at this point in time, what in her evidence, was really about Lim 2, details of the banking route, as opposed to Lim 1. But at the hearing, I think it's fair to say the focus really shifted to a complaint about Lim 1. The second point, which is important, is at paragraph 13, Roman 1. Ms. Zolotova accepts the certificate was purely on its face a compliant certificate. And I say that's important because if the order, as a matter of its proper construction, required express specification of further steps or details, then the certification would not be compliant on its face. Something is compliant on its face, it is compliant with the terms of the order. Now, for the purposes of the appeal, I need to show the judge was wrong on Lim 2. And what the judge does, if you turn over the page 85, is he considers Lim 2 at paragraphs 15 to 20, the question of the construction. But my lords, I think it'd probably be sensible if I first very briefly look at Lim 1, and that's logically the first point. And of course, I endorse what the judge says about Lim 1. It's my learned friend who takes a point on Lim 1.
Can I
Yes.
just pick up a very small point?
Yes.
As far as the chronology is concerned, you said the hearing was on the Tuesday.
Yes.
I think the 15th of October, which seems to be what's said in the chronology at page 76.
Yes.
But it's not what's said on the face of the judgment, which has a hearing date of 21st
Yeah.
of October. That's wrong. So.
Well, that is wrong. The reason why that is there is the judge didn't circulate the judgment in draft, as it were. He handed it down in draft on the 21st of October. I think that's why the 21st has slipped in. The actual hearing was the 15th of October.
So the judgment, the approved judgment is handed down on the 21st.
I think Sir Anthony Mann would say it was handed down subject to corrections.
Yes. Well, that's still a final judgment.
Yes, no doubt about that, yes.
Yes.
Yeah.
And so when it says 21st October 2022,
That's wrong.
It's correct apart from the year.
That is correct, yes. That 21st of October 22 is correct, because that's the date it's handed down.
Should be 24.
24, sorry, yes. The hearing date is actually wrong.
Right, so that should be 15th.
That should be
Very
15th,
much.
yes.
These things are not the most important, but it's helpful to get them right.
Well, there is a point about the chronology. I can make a point later on that. It's not the strongest of points, but it's important. And as to Lim 1, what needs to be specified was that funding arrangements are in place to allow the trial to take place. What does that mean? The June judgment, which we looked at, referred to funding arrangements with a funder. And the question to ask was, does the claimant have any arrangements with any funder to make available funds for the trial? And that's why paragraph 21 of the judgment, that's page 86, the judge talks about a certification of availability. So it's making available funds for the trial. And it's to be made by the solicitor, not the clerk. So that's important. It's to be made by the solicitor. What the judge then does, from paragraphs 22 onwards to 31, is effectively he looks at my learned friend's arguments on Lim 1. So effectively what my learned friend does is he relies on matters that took place after the certificate. I'm going to come back to that so far as I need to in the respondent's notice. The key point that I need to make is at paragraph 32 on page 88. And this might be the paragraph that my Lord Justice Nugee had in mind.
No. He's sceptical.
Oh, that's later, yes. The judge does say at 32 that I do not find the certificate is false in this respect, i.e. Lim 1. That's the third line. And the certificate was intended to be a mechanism for allowing the claimant solicitor, after making proper inquiries, to provide reassurance based on his own assessment. He did not have to justify it with particulars, and even now there is no obligation on the claimant to specify what the arrangements were. And he says, well, there may come a time when the material suggests an absence of arrangements, but I don't think that yet the evidence is there quite. Then he makes a point about the fact that funds have not yet found their way to Steptoe for the purposes of the forthcoming trial. In my submission, that's of no relevance at this stage. And he finds that the certificate, I'm not prepared to find, the certificate was false in respect of paragraph 1. And my lords, why was Mr. Elliot satisfied that there were funding arrangements in place? If you pick up the evidence, please, at the supplementary bundle, tab 13. And it's page 83. So this is the witness statement of Mr. Elliot, which is filed on the 11th of October, so the day after the application is issued. And if we turn over the page, please, to 84, paragraph 5, Mr. Elliot refers to the background of the certificate, makes the point that the claimant has limited funds from the estate, refers to the effect on payment routes to transfer funds from Russia to the UK. Turn over the page to page 85. Paragraph 6 refers to the difficulties requiring the adjournment. Paragraph 7, following receipt of the order, that's the June order, I immediately forwarded it to Mr. Nugee at Caesar. Then he says, over the next 2 months, I regularly chased Caesar for funds, repeatedly reminding them that the court required them to provide us with funds to pay the wasted costs caused by the adjournment and to ensure that funding arrangements were in place to fund the adjourned trial. Then there's this important sentence. I also told them that they had to pay our outstanding invoices by the 31st of August 2024. That's the point on the deadline that I'm going to come back to. But that's the important evidence. That's why payment is made on the 30th, the outstanding invoices. In paragraph 8, during the last week of August, we received significant payments direct from Mr. Livershitz from his account at Raiffeisen Bank. These were enough to pay our outstanding invoices and the wasted costs order. I understood at that time from Mr. Nugee that Raiffeisen had lifted restrictions on the amount of funds which could be sent to us and was now able to make large payments to us. He goes on, believing that Raiffeisen could make these transfers to us going forward, I was able to prepare the certificate. Paragraph 9, he says he wasn't aware of the announcement on the 15th of August. In paragraph 10, he says this, I believe that the payment route described in the certificate was in place and that funding would be provided by Caesar, current funder, using the bank account of its owner. Over the page, page 86, Mr. Livershitz at Raiffeisen to transfer funds directly to DCQ Legal. At paragraph 11, it did not cross my mind I should make inquiries to establish if the policy was going to change. The certificate is filed at 1417, paragraph 12, and paragraph 13. Contrary to what was said by the first defendant, at the time I signed the certificate, I did not know that Raiffeisen intended to stop all foreign currency payments as from the 2nd of September. So that is the evidence.
As from the 2nd of
Yes.
September, but it's also, you had to put your order in by 1600 Moscow time
Yes.
on the 30th
Yes.
of August.
Yes.
So by the time he files the certificate, it was in fact untrue.
That's, well, I'm not sure that is correct. No, man, I wouldn't accept that. Because as at the date, the certificate, if you look at the certificate itself, what is said, paragraph 2, so this is supplemental on tab 4, page 28. The route for the funding will be provided by Caesar using the bank account of its owner to transfer funds directly to this firm, and that's filed at 2:17 London time. The payment is received by Steptoe directly at 3:17 London time. And we see that in the evidence, my lord. If we go, please, to Mr. Dooley's third statement. So, supplemental bundle tab 15, page 92. There's a screenshot of the transfer instructions, and the court can see in the middle timestamp 1513 BST. So that would be 5:13 Moscow time, and that's from Raiffeisen. So a direct payment is made after the certificate is filed.
Okay.
So that's the point there. And I have a separate point, my lord, which I'll come to, is whether or not, if you like, the truth or otherwise of the information matters for the purposes of compliance with the order. And I'll come to that.
Okay, I don't want to take you out of your
No,
course,
no.
but I will say now that I find it very surprising that you can confirm something if it's untrue.
Well, my lord, perhaps what I should do on that basis...
Do it in your own course, because it's a point you have to address.
Yes, of course. Yeah.
Just thought I should tell you now that I have difficulty with that submission.
And I will explain, when you give further information, what needs to be certified or given for the purpose of compliance with the order.
Yes.
I've made my submission that the judge held certificate was not judge correctly held the certificate was not inaccurate on limb 1, and in effect what my learned friend says is that Mr. Elliot was reckless on limb 1. That's effectively the gist of the point, and that really goes to good faith, which is why I'm going to come to that after I address ground 2. So now, can I then come to limb 2? Limb 2, if we go again, if we look at the...
Can I, just before you leave limb
Yes.
1, what did the judge mean by saying funding arrangements are in place? Did he mean Mr. Lubashitz has funds and he's willing to put them behind the litigation? Or did he mean Mr. Lubashitz has funds, he's willing to put them behind the litigation, and there are arrangements in place for those funds to reach London?
I don't think he meant the latter, my lord, because arrangements in place to reach London would really trespass on limb 2, the banking route.
So in your submission, it's sufficient for limb 1 if Mr. Lubashitz has agreed in principle to fund the litigation, yes, and has the funds to do so, even if there's no known mechanism by which they can be got out of Moscow and into London.
Well, my lord, it would depend what the arrangements are. But
no, this is a question of what arrangements means. Does it mean arrangements with a funder that they will fund the litigation, or does it mean arrangements sufficient for the funds to arrive in London?
I don't.
That's a question of construction. What arrangements means, and it doesn't matter what the actual facts are. It's what the order.
It's the former, right, in my submission, and the reason why it's the former is what the judge says at paragraph 21 of his judgment, the certification of availability. And you can test it this way. Funding arrangements does not mean, for example, the solicitors need to be in funds as at the 30th of August or the 31st of August. There's no reference at all to when the solicitors need to be in funds. That's why in my submission it simply means funds available. Limb 2 concerns the transfer.
Okay.
So, my lord, can we then come to limb 2, which requires details of the banking route? And there are two interrelated points. First, before we move on to limb 2, Mr. Mukherjee very kindly reminds me, of course, limb 1 is a general certificate. So I would also rely on the fact it's a general certificate to the effect that funds are available. Doesn't go any further, doesn't need to go any further than that. May I move on then to limb 2? And there are 2 points here, and they're related. As a matter of construction, what does banking route mean? And secondly, what is the significance, if any, of the word directly? And I say the judge erred on both points. Now, as to the first point, to understand the banking route, one must go back to the June judgment. And we saw earlier that the judge considered different routes that had been potentially available, but as at June had failed. The non-Russian bank accounts had failed. The transfer from them had failed. The second route was the transfer from Mr. Lubishev's account. That had, at 28th of June, had failed. It was no longer available at that point in time. And so in my submission, when we come to limb 2, and you have to certify details of the banking route, it is satisfied by identification of the account from which the transfers are going to be made. That is, on the objective approach to the construction of the order, what limb 1 means in the light of the June judgment. Can I make that good by looking at the judgment, paragraph 17? So this is Bundle C, Core Bundle, tab 9, page 85. The judge here, from paragraph 15, concerns construction, and he looks at direct and payment route together. I want to look first just at what a banking route means. And what the judge says at paragraph 17, he refers to the complaint about the second paragraph of the certificate. And then he then says, the 5th line of paragraph 17, the requirement to specify a route for the funding arose precisely because at the time I required the certificate. It was apparent there was no clear route for monies to leave Russia. The evidence was that attempts were made to engage an Italian and a Hungarian bank, and they failed. They were to have been, quote, part of the route. But, my lords, that's not what the June judgment says. The Italian account and the Hungarian account are described as part of the route. As at June, they were in fact the route. Then the judge says, refers to Dubai. That was another route that failed. And then he refers to what had been the 4th route, payment route in June. Some monies had been transferred from RB, Raiffeisen, on a sporadic and limited amount basis. So the judge actually is, and then at 18, he says that's the context in which I required the route to be specified. And he says this, what was required was that it be shown how it was that money could leave Russia and end up in this jurisdiction, when the evidence indicated that was very difficult. And the purpose of that was to ascertain whether it really was going to be possible to get the funds here for a trial, so as to avoid the prospect of there being no funding for the claimant, and that becoming apparent at a time when resources would be wasted in the apparent false expectation of a trial. And the error is the last sentence. Any intermediate steps would have to be specified as part of that route.
Is he in error when he says what was required would it be shown how it was the money could leave Russia and end up in this jurisdiction?
Lord, yes, he is in error there.
What's wrong with that?
Because the details of the banking route are, you identify the banking route, and so you say what the route is. What you don't do is set out all the staging posts. You don't do that because the order doesn't say that. And you test it this way. Say there is no relationship at all between Raiffeisen Bank and the bank in London, and instead transfers happen by correspondent banks, and there are lots of correspondent banks. In my submission, the certificate for Lim 2 did not need to set out the details of all those correspondent banks.
That's a different point.
Well, my lord...
Let me put to you why I say
Yes.
it's a different point. If I go onto my online bank account and send money to somebody else's bank account in another country, as far as I'm concerned, I'm sending that money direct to them. Now, as a matter of interbank mechanics, they may not have accounts for each other, in which case they have to use correspondent banks in London and New York or wherever, and it's all done through a system of credits and debits, and as Lord Millet says in Foscott and McKeon,
Yep.
you don't actually get gold coins crossing the Atlantic when I pay someone in the States. It's all done through entries. But I don't need to know that in order to say, truly, I've sent money directly from my bank account to your bank account. So I'm not talking about the mechanics of how that works, but it's quite different if my bank says, we can't send money to the States. What we can do is send money to Paris. And there's a bank in Paris, and they can send money to the States. But that's a different route from my bank sending money directly to the States. And it seems to me, speaking for myself, that it's entirely plain from Sir Anthony Mann's two judgments that what he meant was the latter. Are you sending money directly from Moscow to London, regardless what the mechanics are of doing it? Or are you getting money out of Russia by opening an account in Hungary or in Dubai or in Italy or Spain or anywhere else, getting money from Russia to Hungary or Dubai and getting it from Hungary or Dubai to London? That's a different route. And that's what he says in this paragraph. And at the moment, I have great difficulty in seeing why he's wrong about that.
He is wrong in saying you need to specify the intermediate steps. So, for example, say the money had come from the Hungarian bank, and say, which is the account, from Caesar, not Mr. Libishet's account, and there's no reference, we're moving on to directly now, but there's no reference to direct or otherwise. In my submission, how the money gets to London from the Hungarian bank is not relevant for the purposes of Lim 2. What the judge wanted reassurance about was that there was a route available to transfer funds to London. I accept that. How they get to London was not actually relevant for the purposes of Lim 2. That is my submission. And the reason I say that, I obviously rely on the point about corresponding bank, I rely on the point on the construction of the order, construed strictly. If you needed to identify all those different steps, the order needed to say so. The key point at this stage, for the purposes of truth or accuracy or otherwise, is that the route which had been unavailable in June transfers directly from Mr. Libishet's personal account had, so far as Mr. Elliot was concerned, become available by August. And that's why he lists the account in the certificate that we saw earlier at Supplementary Bundle tab 4. And if we turn to paragraph 35, where the judge comes back to the question of Lim 2, page 89, the judge considers why the accuracy of the routing was important. And this might also answer Lord Justice Nugee's point. Unlike the obligation about funding arrangements, where detail did not have to be given, details of the routing did have to be given. That was to prevent glib, untested and unverified generalisations, because the evidence up to the date of my order did not indicate a great degree of hope that a route would actually be available. Therefore, the route had to be specified in order that it could be seen that problems of finding a route had been overcome. Now, as at the 30th of August, so far as Mr. Elliot was concerned, the problems of finding the route had been overcome because it was direct from Mr. Libishet's personal account. And that's why I say it was accurate to say Lim 2, to certify Lim 2 in the way that Mr. Elliot did. And there are two further points on banking route before I move on briefly to directly. The first is that the suggestion that intermediate steps needed to be specified is inconsistent with Ms. Zolotova's concession that the certificate is compliant on its face. I do say that.
Why?
Because, my lord, if the certificate is compliant on its face, it's compliant with the terms of the order.
But the certificate says it's going to be done directly. It does specify the route.
Yes, well, I'm going to come to directly in a the point on directly in a moment. Remember, at the point in time it's filed, which is the point at which actually needs to be tested, it was correct to say that payment will be made directly. And we know that because money comes to Steptoe directly after the certificate is filed. And the second point is that identification of the account as the root was also Miss Zolotova's own understanding of Lim 2. And I can make good that point. If we go, please, to Supplementary Bundle, tab 6. It's the letter that, page 51.
September.
Yeah, so this is a letter, 10th September, that the Miss Zolotova solicitor sent to the clerk, to Sir Anthony Mann. And it's where Gresham Legal raise the problem with the certificate with the court. And they make various complaints. And you see at the foot of the page, the certificate provided does not provide adequate details of the banking route. And if you turn over the page, page 52, they set out their concerns, including concerns about the veracity of the banking route. And if we turn, please, to page 53, this is the key point. At the top of the page. Third, no explanation has been provided in the certificate as to what has changed since late June to enable Mr. Liebeschitt to use his Raiffeisen bank account to process the necessary transactions. Then it complains about the lack of detail in the evidence. And if the court sees in the middle of the paragraph, no detail has been provided in the certificate addressing what, if anything, has changed since the time the claimant applied for an adjournment of the trial, and why it is now said that the use of Mr. Liebeschitt's personal Raiffeisen account, which was not sufficient in June, now presents a viable funding route. So my submission is that the court in the June judgment understood what a funding route was, as indeed did Mr. Zolotova, as indeed did Mr. Elliott. The fact that Mr. Liebeschitt's personal account was identified as a funding route was sufficient for the purposes of Lim 2. Can I then move to the next point quickly about directly? And this, of course, is linked to my submission on banking account, because if the court is with me on my submission as to what a banking route means, then the question of directly actually does fall away. As at the date of filing, or the time of filing even, 2:17 in the afternoon, the certificate identified a route that was available for funds to be provided, in that funds are paid directly or received directly after the certificate is filed. My submission is that the use of the word directly is not in fact material. I made my point earlier about the question of correspondent banks. For the purposes of the court, what mattered was that there was a route from which funds could come to make funds available in the UK to the solicitors. And quite how that happened and the detail required was not necessary. And I do say that the immateriality of the word directly, again, is evidenced by Ms. Zolotova's own correspondence. We look back, please, at the judgment, paragraph 23. Page 86. This is when the judge refers to Gresham raising the various points in September, and your lordships will see the last sentence in that correspondence, the query about RB's inability to effect direct payments was not mentioned. The point really is this. If a banking route did not need to specify intermediate steps, then it follows in my submission that the use of the word directly, though it becomes inaccurate from the 2nd of September, is not material for the purposes of Lim 2. That's the submission. And the upshot of the point, my lord, is that the claimant, Ms. Kireeva, through her solicitor, gave an answer in the certificate on Lim 2 that was not plainly incomplete and not insufficient. It complied with the terms of the order. I move then to ground 2.
Yes.
And also the...
Just
yes.
before you
Yes.
go into ground 2, is it an accurate summary of your submission on ground 1? Let's leave aside Lim 1. I understand
Yes.
your
Yes.
points on Lim 1. But on Lim 2, it was strictly speaking accurate when the certificate was given to say that direct payments from the Moscow bank account to London were available. Mr. Elliot had no reason to think that they would not remain available, and therefore the certificate was a good certificate, even though, actually, to anybody who knew the true position, unless you had put the order in by 2 o'clock on that day, Moscow time, you could not rely on that route to fund the trial because the route was about to be closed and had indeed already closed, in the sense that unless your order was already in, you weren't going to get any money out. And you say that doesn't make the certificate inaccurate?
Yes, it's 4 o'clock Moscow time rather than 2 o'clock.
Sorry, 4 o'clock
yes.
Moscow time.
Yes, my lord, and of course the key point is when you said to anyone who knew the true position. So we're going to look at now the question of the truth or otherwise of the answer or the information given, because that comes into into good faith. But if the court is against me on material accuracy, which I believe is what Lord Justice Nugee is saying, then I rely on ground 2. That's where ground 2 comes in, because I really have two points. Ground 1 is, what does the order mean? I can comply if I'm right on what the order means. Ground 2 is also compliance with the order. And if I'm wrong, if the court's against me on material accuracy, then we come to ground 2. And then I pick up the points that Lord Justice Nugee has posed to me. But yes, broadly, my lord, yes, your summary of my submission, I think, is correct. Yes.
I see. Thank you very much.
So, my lords, I say then, even if the certificate was inaccurate in any material sense, it would still comply with the order. And that's because it was not provided in bad faith, and therefore does not fall to be impugned for the purposes of compliance with the order. I set out the principles at paragraph 17 of my skeleton. So that's core bundle tab 5, page 35. Beginning paragraph, impugning the certificate.
Yes.
And where the issue is, has there been compliance with an order to serve a document, and there's an argument over the contents of the document. And the question is the document or the information given, is it made in good faith rather than illusory? And that derives from a decision of this court in Rees and Wolfe, which we'll look at. I would take the court through all the relevant authorities and the debate. If we turn to the judgment, please, my lords, tab 9, page 49, paragraph 49, this is page 92. This is where the judge deals with the Rees and Wolfe point. He refers to Rees and Wolfe at 49. And then at paragraph 50 to 53, he refers to the debate between the parties that we will look at. And at paragraph 54, the judge says, I don't consider I have to try to resolve any conflict. First, because the case concerns documents and compliance complaints which are different from the document in this present case, And second, in any event, I consider that if bad faith is necessary, it has been established. The judge, in my submission, was wrong to hold the certificate was invalid because it was provided in bad faith. And as to my submissions, in summary, they are these. First, the authorities show that the relevant test for the purpose of compliance is that the document or the answers, information in the document are given in good faith. Second, that test applies to the certificate. Third, the judge was wrong to hold that bad faith had been established, and I'll explain why in the evidence. And the fourth point is even if bad faith was established on the part of Mr. Lubashitz and Mr. Nurtinov, that does not take the certificate, because neither the claimant nor the solicitor were found to be dishonest. So those will be the submissions. So can I start with Rees and Wolf, which is in the authorities bundle, tab 2, page 11. The court will see from the head note that this case concerned the delivery of further and better particulars. The defendant delivered the further particulars within the stipulated period, but it was contended they were not a full compliance with the order, and that was because the defendant stating that he was unable to give dates or details until after discovery, or possibly not at all. So that was the issue in Rees and Wolf. And Mr. Justice Devlin considered whether the document did comply with the order, and he said that it did, and it went on appeal. And if we go to the judgment of Lord Justice Somerville, page 13, what Lord Justice Somerville did is he first refers to the passage of Lord Justice Green in Abelian and Innes, effectively that where you are looking at unless orders, what you need to do needs to be specified in absolutely and perfectly precisely in their terms. That's the point I cite in my skeleton.
Yeah.
Yes. And then Lord Justice, then he refers to Mr. Justice Devlin.
Well, he recites
Yes.
part of Mr. Justice Devlin's judgment and says the learned judge was right for the reasons he gave.
Yes.
This was a very well-known case in the far-off days when I used to do summons for particulars before Queen's Bench Masters, as they then. It all depends.
Of course.
If
yes.
you're ordered to give particulars and you produce 25 paragraphs, 3 or 4 of which say, I don't know yet, or we're looking for further documents or something, then probably that's compliance with the order. On the other hand, as Mr. Justice Devlin says, just the fact that you produce a document saying particulars, which then says nothing, is not compliance.
Exactly, my lord.
All right.
Page 14.
We know that.
Yeah, and the point on page 14, though, is I of course rely on the point, it's a document that must be in good faith.
Yes.
Not that's the point I rely on. That's the starting point. And then that test is endorsed by the Court of Appeal in Rail Credit. That's the next authority, tab 4. And you see from page 33, this concerned a failure to comply with an unless order for discovery. That's the second line of Lord Justice Tuckey's judgment. And what happened in this case is a discovery list was filed, but it was said that the list was, quote, obviously deficient. So if we look at page 34 of the judgment, of the bundle, sorry, the foot of the page, you see the unless order in Rail Credit. And then page 35, the first main paragraph, beginning on the 2nd of March, you see the complaint that there were very large gaps in the list and some documents were obviously missing. And various evidence was served. If we turn to page 36, of the judgment, of the bundle, sorry, the position of the party receiving the list, this is by the hole punch, third of the way down, was the evidence of the lenders was quoted was so incredible as to be unbelievable. And the judge at first instance agreed that the list was obviously deficient. And one sees that in the quotation in the middle of the page, beginning, "I would not suggest." And what the judge says, this list did not, on the face of it, meet their discovery obligations because of the obvious and substantial lacuna in it. And he goes on, discovery is still woefully inadequate, and so on. So that's what the judge said. And the Court of Appeal, however, looked at the test. Is that correct? This begins at page 37. Yes. This is Lord Justice Tuckey still, yes. And he refers to Appellant and Innes, which we've just looked at, Lord Justice Green, clearest and most precise language. And then he refers to Rees and Wolfe in the field of further and better particulars. If we turn over the page, this is page 38. First point to note before we get to Rees and Wolfe, court can see in the second paragraph there's a reference to the evidence that was filed. And the point is made, there'd been a complaint about the adequacy of the evidence, whether or not documents existed or otherwise. The court can see the penultimate sentence. If the deponent says there are no documents in the class specified, that is conclusive. However,
where are you reading from?
Oh, sorry, my lord. This is the second main paragraph, page 38 of the bundle.
I see.
This is just a point on evidence, so it's slightly out of course, but it's where it comes in the judgment. It's the two last sentences really about if the deponent says there are no documents in the class specified, that's conclusive. However incredible that might be, the position is to say with an affidavit verifying the list. And then in the third paragraph, the court looks at the critique that had been made, that effectively it's not a proper list. And the last paragraph, Lord Justice Tuckey applies language of Rees and Wolfe. It could fairly be described as a list, it was not illusory and so on. The judge adopted the wrong test. And
the short paragraph on page 39 highlighted is quite useful as well.
Yes, exactly. And this is important. If it's patently obvious, again, on the face, then you can infer lack of good faith. As it says, this was the concession. Court could infer lack of good faith that was obvious from patent deficiencies in the list. It had been prepared in apparent but not real compliance with the obligations to give discovery. So I do rely on that as well. So that is real credit. And this approach has been followed in the CPR context. Now, the editors of the White Book at page 139 of volume 1, they refer to Rees and Wood. If the court has it, a White Book available, otherwise I just give the reference. So it's page 139 of volume 1. It's in the, it's a paragraph 3.9.10, and 139 is talking about compliance with an order. And your lordships will see in the third paragraph from the foot of the page, beginning filing a cost budget, there's then reference to serving a list of documents which was deficient, did not by itself amount to a failure to comply with an unless order to give standard disclosure, provided the list was not illusory. That's a reference to Lacatania, Mr. Justice Hampton's decision that I rely on. And then there's reference to Eurasian, Mr. Justice Andrew Smith, reference to Rees and Wolfe, And then there's reference to QPS consultants, which I'm going to address, which my learned friend places much weight on. But the important point at this stage is that there are a number of authorities in the CPR context in which Rees and Wolfe is applied. Not just Lakatamia, Mr Justice Hamblin, but also Mr Justice Hart in Scottish and Newcastle, that I refer to in my skeleton, it's in the authorities bundle, as well as Euro-Asia, which I'll come to. What is said against me is that bad faith, the Rees and Wolfe point, no good faith and so on, is not the test because it's been eschewed by QPS, the reference that we just saw in the White Book. That is not correct. Can we go, please, my lords, to tab 5, the next tab in the bundle, authorities bundle, which is QPS itself. And this again is a case that concerned an unless order for further and better particulars. See that at page 42 of the authorities bundle. It's in the middle of the page. That's the unless order itself. And what was held, the paragraph beginning the 8th of October, was the particulars were so deficient, the defendant should be held in default of the unless order. And the judge's conclusion, this Judge Howarth, is cited. He says there have been substantial failures to answer many of the requests, and if the court sees the third sentence from the foot of the paragraph, I accept the submission that many of the replies are illusory and don't provide the information requested. And what happened over the page at 43 is that rather than striking out the whole of the defence, the judge thought that would be disproportionate, and he only struck out part of the allegations. And then the court can see, a third of the way down, the principal issue in this case was, had there been a default in compliance with the unless order? And my lords, can you see the submission that is made? This is a submission by the appellant, and it's important to look at the submission to understand what in fact the issue had been. The submission by Mr Rees, Queen's Counsel for the defendants, was founded upon the judgment in Rees and Wolfe. And the submission was that documents comprising the further and better particulars delivered on the 7th of October were made in good faith and, comma, taken as a whole or fairly described as particulars. That was the submission. Taken as a whole, these are fairly described as particulars. Mr Rees accepted that some of the particulars were plainly inadequate, but he said that didn't accept the document as a whole. So that was the submission that was made. There's an examination of Rees and Wolfe. If we turn over the page, please. Page 44, the submission is recorded again in the middle of the page. And it's the second half of the middle paragraph beginning, in these circumstances, Mr Rees argues. Mr Rees argues the judge really had no alternative but to regard the document as a whole as one made in good faith and fairly called particulars. And he should have rejected rather than accepted the submission that for the particulars to be found illusory, it was sufficient to show that in relation to a substantial number of the requests, no genuine attempt had been made to answer them. And the Court of Appeal rejects that submission. Ably though the argument was advanced, I would reject it. And what the Court of Appeal, this is Lord Justice Simon Brown. What Lord Justice Simon Brown says is he first refers to the first instance judge, Judge Galliland, and he notes that the judge had been referred to real credit, which we've just looked at, and then he quotes what the judge had said. In my judgment, the order does require each of the requests to be answered. The order does not, it seems to me, give the defendant the option of answering only some. And then he goes on, the sanction is applicable if all of the requests are not answered. Then the judge says, there seems to me nothing in Rees and Wolfe that is inconsistent with this construction of the order. Another way of expressing this is to say there must have been a genuine attempt to provide answers to the questions. That's what the judge said at first instance. And what Lord Justice Brown says is that you can't reconcile what the judge is saying about Rees and Wolfe with his decision that you need to answer all of the particulars. You can't only answer some. You see that, excuse me, you see that in the second paragraph on page 45, beginning, if Rees and Wolfe remain good law. What Lord Justice Simon Brown is saying is that if Rees and Wolfe remain good law, I would, I confess, have some difficulty with that approach. To say in a case like the present, which involves a very large number of requests, that the order requires each of the requests to be answered, and the sanction is applicable if all the requests are not answered, is irreconcilable with what Mr. Justice Devlin said, which is to look to see if the document as a whole can fairly be entitled particulars. And that's why Lord Justice Simon Brown then says Rees and Wolfe is not applicable at any rate in the context of further and better particulars. i.e., in the context of further and better particulars, you are not applying the Rees and Wolfe approach of is the document, looking at the document as a whole. You are looking at the individual, have there been answers to each of the requests? But nothing at all is said here about good faith or lack of good faith. I'll come to that in a moment because good faith is still part of the test. Lord Justice Simon Brown explains why Rees and Wolfe, as regards looking at the document as a whole, is not good law any longer, for the rest of page 45. And then on page 46, he sounds two notes of caution. This is the second paragraph. First, an order for further and better particulars is not to be regarded as breached merely because one or more of the replies is insufficient. That's the first note of caution. The correct view, if the answers could reasonably have been thought complete and sufficient, then the correct view is that they require only expansion or elucidation. The second point, second note of caution, although I regard an unless order as breached whenever a reply is plainly incomplete or insufficient, I would not expect the court strikeout discretion to be invoked. He cautions against satellite litigation. I say that's exactly what happened here. Why do I say that good faith is not affected by anything that Lord Justice Simon Brown has said? Look at what Lord Justice Waller says in the same judgment. So that, my lords, if we turn on, beginning at page 50, Lord Justice Waller, he agrees with Lord Justice Simon Brown about you're not looking at the document as a whole. You've got to answer each of the requests. Look at the foot of page 51. Accordingly, the judge was right in saying the order required each of the requests to be answered. But then he goes over that, if we go though to page 52, the judge says this. Mr. Rees submitted that if that were the proper construction of the order or similar orders, that is going to lead to lengthy analyses before the masters, relating to whether a request has been properly answered. That, in my view, should not be so, because what the court is concerned to examine is whether there has been a genuine attempt to answer the request. That is so because the court will not contemplate enforcing the sanction of strikeout and so on unless there has been a failure to make genuine attempts to answer the request. Next paragraph, he refers again to a genuine attempt to answer. And then, final paragraph of his judgment, again, a reference to a genuine attempt. So 4 times he's referred to genuine attempt. And then Lord Justice Tuckey, who of course was in real credit, agrees. So the submission is that good faith still remains the test, part of the test for compliance. That's why you see it in Lacatamia, Scottish and Newcastle, and so on, in the CPR context. It's not right for my learned friend to say that it was doubted in Euro-Asian, which is in the authorities bundle at tab 16. In that case, Mr. Justice Andrew Smith didn't engage in the debate. Now, can I come to a point that has emerged yesterday or 2 days ago? Yesterday, my learned friend referred to a further authority called Lloyd's Development. Now, my lords, I hope that is in your authorities bundle at tab 22. It's a recent judgment of Mr. Justice Constable. And it concerns an unless order and breach of unless order. And if we turn, please, to page 476 over the page, the argument of paragraph 6 concerned adequacy of compliance with the order. There's reference to QPS. And then page 477. That case, QPS, made clear that the earlier approach of the courts in Rees and Wolfe was no longer applicable. That had required the act of compliance to be a document produced in good faith and not illusory, rather than one of whether the demand for particulars had been substantially met. Now, that is correct in that if you're looking at the question of particulars, as a whole, Rees and Wolfe has gone, but that says nothing about the good faith part of Rees and Wolfe. And then importantly, paragraph 7, Mr. Justice Constable refers then to another authority called Gravity Highway, which is a decision of Mr. Justice Butcher, who talks about the construction of unless orders in the CPR context, and he gives a summary. And this again is in the context of further information. Paragraph 1, this is Mr. Justice Butcher's summary. In assessing whether there has been compliance with an unless order for provision...
Don't read it out.
Oh, I'm grateful. The point I want to rely on, my lords, is paragraph 2. The court is not concerned with the truth of the answers or with their logical coherence unless any lack of coherence goes to the completeness or sufficiency of the response.
That's another particulars case, is it?
That is a particulars case, yes, my lord. And that is why, in answer to my Lord Justice Nugee's question to me earlier about, if you like, objective truth of the answer, the court is not concerned when it comes to giving information as to the truth of the answer objectively. The answer needs to be given in good faith. That's my submission. But if you give an answer in good faith and you're mistaken, it's objectively untrue, that does not mean there has not been compliance with the order.
Well, that is your submission.
That's the
and
submission.
Speaking for myself, yes. I don't think reference to numerous cases over the years about the provision of an answer to requests for particulars, even when it's got to an unless order, helps very much.
In my submission, my lord, it helps in that the test for compliance It's not just that I accept Rees and Wolfe is further and better particulars, as is GPS.
Yeah.
And of course, Lacatania is a list for discovery.
Yeah.
The question of documents, the question is, what is the test for this certificate? And I say the test is, was the certificate not provided in good faith?
Yeah.
And a way of putting it is to say, was the information in those two limbs not given in good faith? And that's why I say there is an analogy with further and better particulars. And
Can I just...
yes, of course.
And the whole point of the unless order was Sir Anthony Mann was willing to give your client one last opportunity to have her trial. Only if and only if, funding was available. And to that end, required the certificate to be given that funding was available, specifying the route by which the funding could reach the solicitors, because it wasn't any good if funding was available in Moscow, it had to be available in London. Let it be assumed that the certificate was given in perfect good faith by Mr. Elliot. If it's now apparent, which, subject to anything you say it now is, that the funding route was just not usable, it just wasn't available, surely the import of the order was that you lose your trial, because you were only going to have a trial if you had a funding route available, and you didn't. In other words, regardless, as my Lord says, it's all very interesting what the position is for particulars, which are allegations in one form or another. This is about a confirmation of a true position. And if somebody confirms the true position, somebody like Mr. Elliot confirms the true position, but the confirmation entirely innocently turns out to be completely wrong, then why should you be able to say there's been sufficient compliance? Because you can't confirm something that's untrue. You can confirm I believe something to be true and you turn out to be wrong, but you can't confirm that Vienna is the capital of France, because it isn't.
Well, Lord, the certificate is confirming his belief.
But that's not. I certify that I believe arrangements are in place. It's I certify that arrangements are in place. And there is a route, and this is the route.
Well, the reason why, my Lord, the solicitor had to certify was because, as the judge said, that was important. The judge wanted the certainty or the confirmation from the solicitor. If the solicitor acts in good faith, in my respectful submission, the fact that he is mistaken, does not mean that the certificate itself is invalid. That is the submission. Because in the same way that if you file a document list or you serve further particulars and there are errors in the document list, omissions in the particulars, that does not mean that the unless order takes, it doesn't mean there's not been compliance with the order. There might be arguments as to you need to go further, you should do this, you need to correct, but it doesn't mean that as at the date the certificate is filed, the certificate is invalid. That's the submission.
Well, I understand the submission.
Yeah.
Thank you.
Well, my Lord, and what the judge then does is he rejects the evidence on the interlocutory basis, and I say he was wrong to do so. I'm not going to take up time with the principles at the interlocutory stage, but of course we have in the bundle paragraph 9, authorities tab 19, page 386. This is this court in the related litigation, Kireeva and Bedsamov. Page 386 is the quotation from Lord Justice Reimer in Coyne and DRC about the court not resolving disputed issues of fact without first having the benefit of cross-examination, not ordinarily do so. Of course, it's not inflexible. It may, in certain circumstances, be open to the court.
We know all that as well. So does Sir Anthony Mann.
Yes. But, my Lord...
How you apply
Yes,
that to the facts of this case.
Well, I should look then at the evidence, my lord.
Yeah.
And you go, please, to Supplemental Bundle tab 12, which is tab 12. This is the evidence of the claimant herself, which is accepted. Paragraph, page 80. Paragraph 7, this is the claimant who actually filed a certificate. She says, I understood and believed that funding would be provided using the bank account of Mr. Livershitz. I had no knowledge that Raiffeisen was to cease to make international transfers. The judge accepts her evidence. Then there's the evidence given by Mr. Dooley, the stepdaughter solicitor, of Mr. Libershitz's position. That's Supplementary Bundle tab 15. And if we go, please, to page 91 to begin with.
Just a minute.
Yes, of course.
Before we do this, I'm just looking at the clock for the first time. 12:15. Are you going to be finished by 1 o'clock?
I had said to my friend I'd be finished by 12:40, 12:45.
Right. All right. Well, one or the other.
Yes, I should certainly finish by 1 o'clock.
Good. Okay. Right. Sorry. Which page you take?
So this is Mr. Dooley's statement. Begin page 91, just to show the evidence about the receipt of money, which we looked at earlier, paragraph 11. And then if we turn, please, to page 93, paragraph 17. Here's the evidence that Mr. Dooley, the solicitor from Steptoe, spoke to Mr. Livershitz by Zoom on the 8th of October. He confirmed to me he only became aware of Raifeisen's change of policy in the week of 2nd of September. He confirmed to me that at no point before then had he been advised by his account manager at Raifeisen that no further international payments would be permitted from his account after the 2nd of September, and he had not seen the Interfax publication. Now, my lords, if we turn, and then obviously there's Mr. Elliott's evidence that we looked at earlier, which is tab 30. So if we then turn to the judgment, Core Bundle tab 9, page 90, this is where the judge deals with the knowledge of the falsity. And he deals first with the knowledge of, paragraph 39, the knowledge of Mr. Livershitz and Mr. Nugee. And he says at paragraph 39, last sentence, that nothing is said about Mr. Nurtinov's state of mind. Now, my lords, that is not surprising, because when the respondent made her application, there had been no suggestion in her evidence that Mr. Nurtinov's state of mind was in issue or was challenged. The references in the evidence in support of the application were to the claimant, Ms. Kireeva, Mr. Elliott, solicitor, and Mr. Livershitz. Ms. Zolotova refers to Mr. Nurtinov, first time, in the reply evidence that served on the Monday before the hearing, a few hours before my skeleton. That's the first point. We come back to paragraph 40, page 90. What the judge does is he refers to the various publications which publicise the announcement. And he says, I have no way of knowing how widespread their circulation is. And then he refers to one of the publications which reports that the bank's support services told its customers of the change. The first point there is it's only one article. We actually probably should just quickly look at it, because there is a point here about the weight of what is said. If we turn, please, to the supplemental bundle, tab 19, page 171. This is the insider article the judge has referred to. And the insider article itself does not say what the judge reports it to have said. To the contrary, you can see that the insider article does refer to the bank's customs support unit, but then updated. There's an official statement to the world. Raiffeisen issued a statement. So the insider article doesn't actually support what the judge says. What the judge...
What that's as maybe, but
Yes.
what do you say about paragraph 42 of the judge's judgment?
Yes. I say, my lord, this. The judge overlooked the fact that where you are testing witness evidence and you're concerned with internal states of mind, that is different from external events. There is no evidence that Mr. Libeschitz or Mr. Nurtinov saw any of the public announcements. In fact, the judge himself says whether or not they saw, he doesn't take that into account. What he refers to or relies on are 2 points. First, he relies on the notification of the change of stance given to its customers. That's the first point, my lord. That's what he relies on to begin with. And the point there is that that actually is double hearsay, because it's a report of a report in one of the articles. There's no evidence as to whether or not Mr. Nurtinov and Mr. Libeschitz saw that announcement to the customers. The second point, and this is the important point, is what the judge objectively relies on, which is over the page, at page 91, my lords. What he says is that the evidence and the assertion of Mr. Libeschitz as his knowledge, conveyed in a hearsay statement, cannot sensibly stand against the overwhelming likelihood of their being told, especially in the context of the August payments, which look very much as though they were paid so as to beat the deadline, particularly the 403,000 paid right up against that deadline. So that is the fact on which the judge relies to infer that Mr. Libeschitz and Mr. Nurtinov must have known. They're making these payments to beat, quote, their deadline. The payments, though, were made on the evidence not to beat their deadline, but because Mr. Elliot had asked them to make payments of outstanding fees. We saw, we should go back to the evidence, it's a very important point. Mr. Elliot's statement.
Well, just
Yes,
before we do
of course.
that, if you go back to page 90.
Page 9.
The last, paragraph 42, the last complete sentence. The need to get funds out of Russia must have been a frequent topic of contact between the bank and those two individuals. In this context, it's inconceivable the bank didn't tell them that from the end of August it was not going to be possible. They're the funders of the litigation. Now, wasn't that a finding that the judge was entitled to make?
Not in circumstances where one's concerned with the internal states of mind. 2, there is direct evidence, there is evidence from Mr. Dooley that Mr. Libeschitz had not been told. And 3, importantly, there is an innocent explanation as to why the payments were made on the 30th of August. That's the important point, because if you go, please, to Supplemental Bundle tab 13, page 85, paragraph 7. There's direct evidence from Mr. Elliot to say in paragraph 7, I told them they have to provide funds and to pay our outstanding invoices by the 31st of August 2024. That's the order deadline, not the Raiffeisen Bank deadline. That's why Mr. Libeschitz and Nurtinov make the payment directly. That's the innocent explanation. And that's important because when you are assessing witness evidence against the documents, you are asking, is there an innocent explanation for what happened? And there is an innocent explanation for what happened here. The judge's point actually doesn't really work anyway, because the payments concerned outstanding fees, i.e. past. If you wanted to beat the deadline, you knew that something was about to happen. You're not simply going to pay the outstanding fees, you're going to make some attempt to pay future fees, especially in circumstances when Steptoe is is waiting in the wings. And so, my lords, I say that when you actually look at the actual evidence, what the judge does at paragraph 42 doesn't actually cohere. He infers from a double hearsay statement that Mr. Libeschitz and Nurtinov must have been told. He infers that they deliberately didn't tell Mr. Elliot. So it's a double inference, and that double inference is not consistent with the actual direct evidence as to why payment was made. So, Lord, that is my submission on paragraph 42.
Yes.
And it's important because once one understands why the outstanding fees have been paid and the reason, the judge's suspicions about Mr. Libeschitz and Mr. Nurtinov, in my respectful submission, cannot be sufficient at the interlocutory stage to dismiss the evidence. It needs to be tested in cross-examination. It's rather like, my lord, when one pleads dishonesty and one's looking for something to tilt the balance, or is there something that's not consistent with an innocent explanation? Well, here we have the innocent explanation. It's actually in the evidence. Then we turn to what Mr. Elliot has to say, his evidence at paragraph 43 and following, which the judge does accept. I suspect it's paragraph 45 that Lord Justice Nugee had in mind at the outset of the hearing, at the top of the page, where the judge...
Probably.
Yeah, right. But the important point is he accepts it. And what the judge then does is he comes up, and I don't mean that disrespectfully, but he has a theory that Libeschitz and Nurtinov, they must have known, pure inference, but both the claimant and the solicitor don't know, therefore Libeschitz and Nurtinov must have concealed, must have deliberately decided not to tell them. Now that point never featured in Miss Zolotova's application. In fact, her position was you don't need to get into internal states of mind at all. That was in the transcript. And it's a point that should have been fairly in play before the judge made that finding. I've made some submissions at paragraph 41 of my skeleton on that. I'm not going to take up time now. Now, if I'm wrong about all of that, and the court's against me, and says that the bad faith does take the certificate, does that matter? And the answer to that, my lords, is no. If we go, please, to paragraph 58. Before we get there, 57 is really the judge's conclusion on this, page 94.
Yes.
Which I've made submissions on, the double inference, as it were. But it's 58 that is the judge's conclusion. And he says, well, the bad faith takes the certificate. Caesar are not the client. So Mr. Libeschitz are not the client, but they are the people apparently authorised by the claimant to negotiate matters of funding. Their conduct, therefore, taints the certificate. Now, that's a further error in my submission. The order required the claimant, through her solicitor, to file the certificate. The solicitor, of course, is the agent of Miss Kireeva. Neither the claimant nor the solicitor were dishonest. The certificate did not require anything from the funder. What my learned friend says is that 58 is effectively, quote, a vanilla application of agency principle. And he relies on a passage in Bousted at Authorities Bundle 20, page 420. But the passage doesn't help him. And I very quickly just want to look at it briefly, because it's a point about principal and agent. If we go, please, to Authorities Bundle 20, page 420. My learned friend relies on Rule 2b, liability for statements. This is page 420 at the foot of the page. And over the page, the court will see what is sidelined. But you then need to read on to 8183, which is deceit, division of ingredients, because the tort of deceit raises special problems. And the point here, and the various principles about when is a principal liable for what an agent says. And the principles are set out on page 422, or a summary of the principles. And the position is this: a principal is liable in deceit if he authorises the agent within the scope of his authority to make a fraudulent misrepresentation. A principal is not liable in deceit if the principal himself makes a false representation innocently when the agent knows the true facts. That's page 423 at the top of the page. And that, in my submission, is what has happened here. The representation, i.e. in the certificate, is made by an innocent agent, Mr. Elliot, on behalf of an innocent principal, the claimant. The fact that Mr. Lubashitz and Mr. Nurtinov, who my learned friend says is another agent, I don't accept that, but let's assume, that does not mean the claimant and Mr. Lubashitz and Mr. Elliot are liable in deceit, and therefore the certificate itself cannot be tainted. And that's the key point. That's where the judge has gone wrong. He attributes, he doesn't actually attribute Mr. Lubashitz and Mr. Nurtinov's knowledge to the claimant and Mr. Elliot. He actually says to the contrary, they're innocent, or rather, they haven't acted dishonestly. And on that basis, there's actually no principle at all for the judge to say at 58 the certificate is tainted. It simply doesn't follow as a matter of law. You've got, for these purposes, a third party, Lubashitz and Nurtinov, who we assume, on this hypothesis, are acting in bad faith. But that doesn't taint the certificate, even on agency principles, because the representation is made by the principal, innocently. So, Lord, that's a submission on ground 2. And I can take, I'm in your Lordship's hands whether you wish to hear me on respondent's notice.
No, I don't think so at this stage.
At this stage, I mean, I've made submissions already on Lim 1. I mean, the short point is that effectively what my learned friend says is Mr. Elliot was reckless and he should have undertaken all these further steps. And I say, as a matter of construction of the order does not say you need to undertake all these further steps. And of course, the judge has found that Mr. Elliot did not act in bad faith. There's no finding of him being reckless. And that's
I see. Yes, well, you more or less covered that.
Well, I was going to say, my Lord.
But if you'd like to say anything else at this stage, then do.
I think at this stage, that's probably all I need to say on respondent's notice. I mean, different professional solicitors may assess the situation in different ways. The fact my learned friend says, oh, Mr. Elliot should have done X, Y, and Z, does not mean he wasn't in a position to certify Lim 1. One point is made, important point is made by my learned friend, that the solicitors were not in funds on the 30th of August. But the certificate doesn't require the solicitors to be in funds. If it did, it would have said so. And the points that my learned friend refers to after the 2nd of September, I say cannot be relevant to the position as at the 30th of August when the certificate was filed. So my lords, that, unless the court wishes to hear me further than that is the point of respondent's notice. I'll see what my learned friend has to say if anything's further material. We come then to ground 3.
Yes.
And I can take this also really quite shortly, because in reality, ground 3 is not an independent, well, the abuse of process point is not a self-standing point. There was no separate ground in the evidence advanced by Miss Zolotova as a basis for abuse of process. If we go please to paragraph 63 of the judgment, so this is page 95, core bundle tab 9, the premise of abuse of process is that the certificate was not at the time inaccurate to the knowledge of the provider, Mr. Elliot. And then at paragraph 64, that's the premise of the argument. 64, if contrary to my finding the certificate was technically valid for some reason, nonetheless reliance on it is an abuse of process because it should never have been provided. That's what the judge says. And he says again at paragraph 66, if contrary to my conclusion, if contrary to my conclusion, the certificate, if contrary to my conclusion, the certificate was invalid or ineffective, nonetheless, I think should be there, its provision and reliance on it was an abuse of process. And the simple point is this, my lords, if the certificate is valid at the time when it's provided, and that's the date at which you test the validity, as the judge accepted, paragraph 63, then in my respectful submission, it cannot properly be said that it's an abuse of process to have provided a valid certificate on the 30th of August. There is no continuing duty on the claimant to update the certificate. Matters may change, and there might be an argument as to what should happen, but the certificate itself doesn't guarantee a state of affairs in the future. And it follows, in my submission, that if the certificate was valid, then it cannot be said it should not have been, quote, provided, which is what the judge says. What the judge says at 64 is that it was a key document for the survival of the claim. And at the end of that paragraph, the certificate and reliance on it, preserving the proceedings, is, in my view, conduct falling within the description of Lord Diplock in Hunter. But, my lords, the claimant was not relying on the certificate after the date it's filed. It has been filed. It's given the relevant certification. After it's filed, Ms. Zolotova is protected for her costs in terms of security of costs, and as regards the claimant, steptoe on the record, and there's counsel and so on. And I do say that to strike out a valid and valuable claim when the opposing party is protected for the costs of its trial is completely disproportionate. I say that there was no abuse of process in the circumstances where the very act required by the order on this hypothesis was complied with. I mean, the gist of my learned friend's complaint is that the claimant should have informed the court as soon as it was apprised of the position concerning refisement ban.
Yeah.
The short point there is the judge does not actually adopt that submission at all, and he made the point at the hearing that Gresham Legal had already told the court on the 10th of September about the position, and on that basis there's nothing for the court to do. If Gresham Legal wanted to take the position further, it could issue an application, which it then did a month later. But the judge does not say you should have told the court. In fact, he disavows that. And I do say, again, if the certificate is valid and there's no continuing duty, how can that rhetorically be an abuse of process?
What about the point he makes in the middle of 64?
64.
The whole purpose
Yes.
of the mechanism was to provide an accurate certificate if one could be provided. So that, etc.
Yes. So on that, as regards the claimant having reassurance, so I think he means actually.
The defendant.
I think he means the defendant. Yes. The defendant, Miss Zolotova, of course, does have reassurance in terms of resources because she has security.
Did she have security for all the costs that could reasonably be expected to be incurred at trial?
She had right, yes. So she had security of £655,700. So those were the order. I think was for her reasonable costs to trial. And I believe it was agreed. It was agreed. There's a separate issue now between the parties as to whether the security is sufficient, because my learned friend's costs now are more than that. But at the time, Miss Zolotova does have protection. As regards reassurance to the court, I mean, the position, my lord, is this. Let's assume we get to the trial date, and for whatever reason, the claimant doesn't have any lawyers. Well, no doubt, the court will dismiss the claim. The idea there could be another adjournment application, which is what my learned friend relies in aid of. He says the alternative is there would have needed to have been another adjournment application. When I say that is not simply not realistic. What would have happened is you get into trial, no one turns up for the claimant, judgment is entered for Miss Zolotova, and she's protected for the costs by the security. So on that basis, my lords, there isn't an abuse of process if there's a valid certificate.
Do you accept what the judge says at 63?
Yes.
Even as at the date of the hearing before me, no proper route has been specified.
Well, my lord, I do accept that because at the date of the hearing, so your lordship, I accept that the route that was used is not in the certificate. Yes, so my lord, you may recall, if you look at Mr. Dooley's evidence, to answer the question, my lord, if you go to Mr. Dooley's evidence, yes, so this is Supplemental Bundle Tab 15, page 94. Paragraph 21. Mr. Nurdanov has confirmed to me a payment of £100,000 is being sent to my firm today via a third-party payment agent. So, insofar as your lordship's question is the route.
Yes, but that payment hadn't arrived.
Exactly, yes.
At the time of the hearing.
Correct, so that's why I accept it, my lord. What, of course, I don't accept is that the payment... I don't accept the contention that the payment route is not from Mr. Libeshit's account. But I do accept that at the date of the hearing, that £100,000 had not arrived. It did in fact arrive after the hearing. There's correspondence on that, but I don't need to make any submission on that. And you'll also see paragraph 22. There's reference to a further payment, £350,000, which is the balance. Again, there's correspondence as to when that arrived. It did not arrive at the date of the hearing.
And do you accept what the judge says at the end of 63? It is plain that the certificate could not have been properly and accurately provided in terms which would fulfil the requirements of the order as at the date that it was required.
So this is the end of...
Last sentence of judgment 63.
63. I don't accept that, my lord, no. Because that's based my submission on ground one. The submission, well, it's ground one together with ground two.
But the accuracy of the certificate is a separate question from whether Mr. Elliot believed it to be accurate. Is it not?
That is correct. And so my submission there is that when in terms of accuracy, as at the date it is filed, there is a payment route because money comes in afterwards. So This is the point I think we
Yes.
discussed earlier. And of course, if I'm wrong on accuracy, I then need to rely on ground 2.
Yes.
Yeah. So I'm sorry, my lord, to...
No, I'm sorry to keep asking you the same questions.
No, but it is fair to say that there are different steps in the analysis.
I understand.
So, my lords, unless there is anything further in which I can assist you, those are my submissions.
Thank you very much. Mr. Mukherjee? Right. I think we'll break off there and resume at 1:45.